In this video, we will cover the important topics of assignment and delegation. These two closely related topics are covered in many first-year courses on the common law of contracts. So if you covered this in your study of the common law, this discussion will be a review. So what are we talking about when we talk about assignment and delegation? Well, after a contract is formed, one or both parties to the contract may wish to transfer either their rights under the contract or their obligations under the contract to a third party. This is what we mean by assignment and delegation. And although they are two distinct concepts, in the business world, parties, and indeed even sometimes lawyers, frequently use assignment to refer to both assignment and delegation. Indeed, subsection 5 of 210 in Article 2 recognizes this. It reads that an assignment of the contract, or of all my rights under the contract, or an assignment in similar general terms, is an assignment of rights and, unless the language or circumstances indicate to the contrary, is also a delegation of performance of duties. So, when one party purports to assign a contract, or purports to assign all of my rights under the contract, or uses similar general terms, it is construed to mean both an assignment and a delegation of the contract, unless the circumstances indicate otherwise. But as we said, the two concepts are distinct. Let's start first with assignment. When one party to a contract assigns a contract, she transfers her rights under that contract to another party. The other party, the transferee, is called an assignee. An assignment is typically effected pursuant to a separate agreement between the assignor and the assignee. Upon an assignment of rights, the assignee stands in the shoes of the assignor. The assignee inherits the legal rights of the assignor under the contract. Specifically, the assignee inherits the contractual right to expect performance from the non-assigning contract party, as well as the contractual right to seek damages against the non-assigning contract party if its promise to perform is breached. From the perspective of the non-assigning party, upon an assignment of a contract, the non-assigning party may only discharge its contractual obligations by rendering performance to the assignee. Delegation is the flip side of an assignment. When one party to a contract assigns a contract, we said that she transfers her rights under that contract to another party. Well, when one party to a contract delegates a contract, she transfers her duties or obligations under that contract to another party. The transferee in this context is called a delegatee. Like an assignment of rights, a delegation of duties is something that is typically effected pursuant to an agreement between the delegator and the delegatee. Note, it is possible and even common for a contract party to both assign its rights and delegate its duties to the same third party. It's possible, but it is not necessary. Indeed, it's perfectly possible as well, and indeed in some contexts common, for a contract party to assign her rights under a contract but not delegate her duties. Note also that delegation by itself does not relieve the delegator from potential liability to the non-delegating party to the contract, that is, the other party to the contract. If the delegator's delegatee fails to perform the delegated obligations, the party to whom the obligation was owed, that is, the counterparty in the original contract, may sue either the delegator or the delegatee. In that case, the delegator may have a separate claim against the delegatee. So, for example, in this diagram, where the buyer has delegated its duties under the contract with the seller to a delegatee, if the delegatee fails to perform, that is, fails to pay the seller for the goods in accordance with the original contract, the seller may bring a claim against either the buyer or its delegatee. In the business world, assignment and delegation of contracts is routine and consistent with the fundamental property principle of free alienability. But the assignment and delegation of a contract also raises potential issues for the other party on the other side of the original contract. A party to a contract might reasonably want to insist on performance by the party she originally contracted with, and not some stranger, some new third party. The seller here may say, I know the party I contracted with, but I don't know this new third party. How can I be sure that I will get what I want out of this contract? How do I know I want to do business with this third party? Parties therefore frequently include in their contracts no assignment clauses. If you have ever reviewed many formal contracts, you have probably seen an example of a no assignment clause. But press pause now to read this example clause. Are these clauses enforceable? That's a question that's answered by Section 210 of Article 2. 210 attempts to balance two competing policies that are fundamental to our legal system. One policy is a policy favoring the freedom of contract, a policy that, as we have said, underlies much of contract law. The other is a policy that favors the free alienability of property, the freedom of an owner from restraints to transfer her property to another. Like the freedom of contract, the freedom from restraints on the alienation of property is a core tenet of property law. Contract terms that restrain or limit the ability of one party to transfer her contractual rights or duties put these two policies in tension. So, how does 210 attempt to mediate the conflict between these two policies? Let's start with subsection 4 of 210, which says that a contract term that simply prohibits the assignment of the contract is construed counterintuitively to prohibit only the delegation of duties. It is not construed to prohibit the mere assignment of rights. The rationale behind this rule seems to be that when parties attempt to contractually prohibit the assignment of a contract, what the parties are normally concerned about, what the parties usually intend to prohibit, is not one party from assigning her rights under the contract, but instead delegating her duties to perform under the contract. Thus, under subsection 4, if the contract parties intend to prohibit the assignment of rights, then they must be more explicit about that intent in the express terms of their contract. To quote the language from the introductory clause of this statute, they must make it clear that the circumstances indicate otherwise. Stated differently, the no assignment clause in the parties' contract must look something like this. Press pause now to read this revised language and see how it makes the parties' intent clearer. So, contract parties retain the freedom of contract to prohibit an assignment of rights under the contract, but to do so, Article 2 requires contract parties to be express and unambiguous about their intention to do so. Even then, however, some courts in some jurisdictions have held that this kind of contract language does not actually preclude the assignment of the contract. An assignment is still possible in these jurisdictions, though any assignment would clearly violate this no assignment clause, putting the assigning party in breach. But that breach would not render the assignment ineffective. The assignment would still be valid and enforceable by the assignee. In these jurisdictions, if the contract parties intend to make an assignment in violation of their no assignment clause not only a breach of the contract, but also ineffective, then the parties must be more explicit about that intent in the no assignment clause. Stated differently, the no assignment clause in the parties' contract must look something like this. Press pause now to read this revised language to see how it makes the parties' intention clearer. So the upshot of all of this is that what is legally required to make a no assignment clause both valid and effective can be fairly rigorous and exacting. But even then, even if the contract parties draft a perfect, explicit, and unambiguous no assignment clause, Article 2 limits the enforceability of contract provisions barring the assignment of rights or the delegation of duties. The limitation on contract terms purporting to prohibit the assignment of rights under a contract are set forth under subsection 2 of 210. Subsection 2 is another quintessential example of the sometimes inscrutable language peppered throughout Article 2. It's the kind of provision that may make you wonder if you could do a better job at statutory drafting. Subsection 2 says a number of things, though not as clearly or as explicitly as a student new to the statute might hope for. First, subsection 2 confirms that unless otherwise agreed by the contract parties, then an assignment of rights under the contract is permitted. So, unless the parties' contract includes an express term validly barring the assignment of rights under that contract, and an assignment is generally permitted. But we must say generally, though, because the sentence then goes on to state an exception to this general rule. Even where a contract does not include an express term validly barring the assignment of rights under that contract, such an assignment is prohibited by subsection 2 where the assignment would materially change the duty of the other party, or materially increase the burden or risk imposed on him by his contract, or materially impair his chance of obtaining return performance. So, even if the party's contract does not include an express term validly prohibiting the assignment of rights, Article 2 implies such a term that prohibits an assignment if the assignment would materially change the duty of the non-assigning party, because the non-assigning party would now have to render performance to some new party, namely the assignee, making the performance by the non-assigning party more burdensome or risky. Consider, for example, a requirements contract, in which a seller is obligated to provide the buyer's requirements of certain goods. If the buyer assigns her rights under the requirements contract to an assignee with substantially higher requirements for the seller's goods, then the assignment could make the seller's obligation to fulfill those requirements unduly burdensome or more difficult. This is the kind of situation that subsection 2 attempts to deal with. So the general rule, subject to the exception we just described, is that unless the parties agree otherwise, an assignment of rights under a contract for the sale of goods is freely permitted. But the provision is even more nuanced than that, because even if the parties to a contract include a perfect, explicit, and unambiguous no assignment clause, subsection 2 limits the enforceability of that no assignment clause in two ways. The first limit is for the benefit of sellers. Note the introductory clause to subsection 2, which makes a reference to section 406 of Article 9 of the UCC. Article 9 is, of course, beyond the scope of this course, but that section says that despite the parties' agreement to the contrary, a seller in a contract for the sale of goods may assign its right to payment from the buyer to a third party in connection with the seller's financing arrangement with that third party. The rationale is that the buyer is unlikely to have any stake or interest in who it pays money to. At the same time, however, the seller's ability to freely assign its right to payment, its accounts receivables, facilitates liquidity for the seller and the free flow of money in commerce more broadly. So the UCC drafters decided that, with respect to the seller's right to payment from the buyer, the seller's ability to assign that right takes precedence over the freedom of contract. Stated differently, the seller's right to assign its rights to payment is essentially absolute and not subject to contractual limitations. The other limitation imposed on no assignment clauses is found in the last sentence of subsection 2. This limitation is substantially less consequential than the first. It reads that a right to damages for breach of the whole contract, or a right arising out of the assignor's due performance of his entire obligation, can be assigned despite agreement otherwise. So, when what is being assigned is not the right to performance, but the right to payment of damages for breach, then the right may be assigned despite the parties' agreement to the contrary. So, to summarize subsection 2, it says that in the absence of the parties' agreement to the contrary, the rights arising under a contract are generally transferable. But again, we must say generally, because even then, where the assignment would result in a material burden or risk for the non-assigning party, then the assignment is not permitted. And even when the parties do include a validly drafted no assignment clause in their agreement, that clause is generally enforceable, but again subject to two exceptions. Thankfully, subsection 1 of 210, which addresses the delegation of duties, is more straightforward, but only somewhat so. First, subsection 1 confirms that unless otherwise agreed by the contract parties, then a delegation of duties under that contract is freely permitted. So unless the parties' contract includes an express term validly barring the delegation of duties arising under that contract, then a delegation of duties is generally permitted. But again, we must say generally, because the sentence then goes on to state an exception to this general rule. Even where a contract does include an express term validly barring the delegation of duties, such a delegation is prohibited by subsection 2 where the other party has a substantial interest in having its original promisor perform. So even if the party's contract does not include an express term validly prohibiting the delegation of duties, Article 2 implies such a term if the non-delegating party, that is the other party to the original contract, has a substantial interest in having the original promisor, that is the delegator, perform. There must be something about this specific delegator. The delegator has a particular skill, character, reputation, or training that makes it important that the delegator perform and not some substitute delegatee. In a contract for the sale of goods, because the buyer's only obligation is typically to pay money, the seller is unlikely to have a substantial interest against delegation by the buyer. Stated differently, the seller is likely to be indifferent as to who gives it the money for its goods. By contrast, the buyer is far more likely to have a substantial interest in who provides it with conforming goods, because who the seller is may have material implications for the source, quality, or nature of the goods that the buyer will receive. So, to summarize subsection 1, it says that in the absence of the parties' agreement to the contrary, duties arising under a contract are generally transferable. But again, we must say generally, because even then, where the non-delegating party, that is the other party to the original contract, has a substantial interest in having his original promisor, the delegator, perform, then a delegation is barred. But unlike subsection 2, however, subsection 1 includes no limitations on the enforceability of a validly drafted clause barring delegation. So when the parties include a validly drafted no delegation clause in their contract, that clause is enforceable. So in this video, we distinguish between an assignment of rights and a delegation of duties, and we covered how Section 210 of Article 2 limits the enforceability of contract terms that purport to bar assignment and delegation. In the next video, we will examine another pair of closely related but distinct concepts under Article 2 cancellation, and termination.